industry under IDRA. That Entry 8 List 2, which deals with intoxicating liquors, cannot also subsume industries for manufacture of industrial alcohol, etc. Viewed from another perspective, the exception, that is the mischievous use, cannot lead to governing of the norm, original intended use, through such construction of Entry 8 List 2. Put into practice, this would translate into legislative regulation of production, manufacture, possession, transport, purchase, and sale of the entire industry and product of industrial alcohol only because of its possible misuse or mischievous use. This reading would be tantamount to attaching to the constitutional intent and absurdity, that is the part governing the whole, or in other words, bringing within the ambit of Entry 8 List 2 something which is an exception as a main aspect of the entry. A power to legislate as to the principal matters specifically mentioned in the entry also includes within its expanse legislation touching incidental and ancillary matters. However, ancillary matters by a backdoor cannot be included within the entry beyond what is covered as the principal. Herein, the ancillary matter being prevention of mischievous use of industrial alcohol would be within Entry 8 List 2, but industrial alcohol as such would not be included. Merely because industrial alcohol by a process can be converted to alcohol for human consumption as a beverage, that does not mean that the state legislature can regulate industrial alcohol. On the other hand, the states, as per Entry 8, have the power to regulate intoxicating liquors, which is for human consumption as a beverage, and is in that regard have the power to prohibit industrial alcohol being converted to alcohol for human consumption as a beverage. This is in order to protect the health of citizens, which is a direct principle of state policy and Article 47 of the Constitution, and in order to prohibit unauthorized use or misuse of industrial alcohol produced in the state from being converted and sold as intoxicating liquors meant for human consumption as a beverage. Then I have looked at the matter from another perspective. One of the contentions raised in this batch of cases is with regard to whether the central government has to, in fact, issue a notified order with regard to regulating the supply and distribution and trade and commerce of any article or class of articles relatable to any scheduled industry, so as to indicate that the state legislature cannot pass any legislation under Entry 33A List 3. In my considered view, the fact that an industry is a scheduled industry under the IDRA would imply that at the time the central government is empowered to, at any time the central government is empowered to issue a notified order providing for regulating the supply and distribution and trade and commerce of the products of such a scheduled industry. But in the absence of there being an issuance of a notified order as such, can the state legislature be denuded of their powers to pass any law under Entry 33A List 3? Having regard to the emerging situation in the economy in the matter of supply and distribution and trade and commerce of the articles or class of articles related to any scheduled industry, the central government may issue a notified order for the purpose of regulating the same so as to secure its equitable distribution and availability at fair prices of the products of such industry. Situation may suddenly arise, make it or expedient to issue a notified order under Section 80G of the IDRA. One cannot envisage the emerging circumstances in an economy such as the Indian economy, where the need for issuance of such a notified order would arise. It could be, for instance, to curb hoarding and black marketeering of a particular article of a scheduled industry in order to stifle price rise. It could be for ensuring a minimum or maximum price for any article related to a scheduled industry, which is a raw material or ancillary input for a product or article of another scheduled or non-scheduled industry. Sudden rise in prices of commodities or articles relatable to any scheduled industry due to natural disasters, floods, famines, financial emergency, or such other reasons could necessitate issuance of a notified order under Section 80G of the IDRA. Of recent occurrence is the COVID-19 pandemic, which would have necessitated issuance of notified orders on certain articles relating to scheduled industry. The field of legislation must therefore be left open for the central government to act by issuance of a notified order as and when thought necessary or expedient to secure an object as stated in the said provision. But can it be held that in the absence of any such notified order issued by the central government, the states could pass laws under entry 33A list 3? Would it lead to a legal confusion and an overlapping and contradiction? This is because if it is held that in the absence of there being a notified order actually issued by the central government under Section 18G of the IDRA, the states are empowered to pass laws under Section 30, entry 33A, and such laws are in fact made under the aforesaid entries by the states. And the central government subsequently decides to issue a notified order under Section 18G of the IDRA. The question would be, what would be the fate of the laws made by the state if they overlap with the notified order issued under Section 18G of the IDRA? Obviously, the control of any industry being taken over by the union under the provisions of the IDRA would imply that the central government is empowered to issue a notified order in terms of Section 18G of the Act, and that when it is necessary or expedient to secure the equitable distribution and availability at a fair price of any article related to any scheduled industry. In such a case, the notified order being issued under 18G of the IDRA would have an overriding effect on the state's laws, if any made under entry 33A list 3 in regard to trade and commerce, etc. A law made by the state under any entry of list 3 or concurrent list is no doubt subject to Article 254 of the Constitution. However, entry 33A list 3 is a very unique entry in as much as the said entry would have to be read in the context of entry 52 list 1, which relates to IDRA, which is enacted by Parliament, and under the said entry, inter alia Section 18G of the IDRA exists. When entry 52 list 1 and any law such as IDRA empowers the union or central government to take certain steps under the provisions of the said act, it would imply that the state legislature is per se denuded of its powers to make any law under entry 33A list 3. Applying the above interpretation, when once the central government has the powers under Section 18G of the IDRA in the matter of regulating supply, etc., then the field has been occupied by the central government to issue notified orders as and when necessary. I have brought this interpretation under the first part of Article 254(1), which says, if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact. In this case, the IDRA is a law which has been made by the Parliament. Therefore, I have said from 110/1953, the field has been occupied. Now, this is what in paragraph 85, Synthetics and Chemicals also says, where it says the state cannot claim that under entry 33 of list 3, it can regulate industrial alcohol as a product of the scheduled industries because the union under Section 18G of the IDR has evinced a clear intention to occupy the whole field. The aforesaid observation, which has led to a reference to this 9th bench, has to be considered in light of entry 52 list 1, entry 33A list 3, and Section 18G of the Act. Then I have given the principle of the doctrine of occupied field with regard to Article 254, first part, subclause 1, and the application of the doctrine of occupied field is a technique adopted by the constitutional courts in order to ensure that there is no potential conflict that could arise between the state laws and the existing parliamentary law, having regard to the nature of the legislative powers, their importance in the socio-economic sphere of governance in the country, and such other considerations. I have also referred to the judgment Ma Aparam Puri of the 5 judges bench, and I have said that the states are denuded of their powers under entry 33A list 3 insofar as scheduled industry is concerned. Then I have said, without going into the other aspects of the case, in my view, this court was not right in holding that since no order was issued by the central government under Section 18G of the IDRA, the legislative field was open to both the central as well as the state governments to take action. That portion of the judgment Karamji, in my view, is not correct. Chand, State of West Bengal versus Union. Then I have said something about importance of industrial alcohol in the Indian economy. It is necessary to note the importance of industrial alcohol in the Indian economy. Industrial alcohol is important to Indian economy for it is used in at least two sectors. One, as a key feedstock for production of various chemicals in the chemicals industry, and two, as liquid fuel to be blended with petrol. As regards the chemical industry, the 22nd Five-Year Plan 2012 to 2017 of the Planning Commission notes that alcohol-based chemical industry occupies an important place in the Indian chemical industry and is a key contributor to the growth of the sector. It also notes the several alcohol-based chemical industries such as in synthetic yarn, drugs, pharmaceuticals, agrochemical, personal care products, dyestuffs, pigments, etc. Then with regard to the contribution of ethanol blended with petrol, EBP program of the Government of India, I have referred to the unstart question of 20th December 2023, where the Minister of State for Ministry of Consumer Affairs, Food and Public Distribution has said as to how the Government of India has been implementing EBP programs and has fixed the target of 20% blending of ethanol with petrol and how the capacity must increase from up by in 2025 to 1,700 crore liters for the meeting the target. Then I have given the Ministry of Petroleum and Natural Gas, Government of India, their ethanol-based growth story. Then I have also referred to Sarkaria Commission report when it comes to these important principles, where I quote again, if the principles of union supremacy are excluded from Articles 246 and 254, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interscene strife, legal chaos and confusion caused by a host of conflicting laws, much to the bewilderment of the common citizen. The federal principle of unity in diversity will be very much a casualty. The argument that the states should have legislative paramountcy over the union is basically unsound. It involves a negation of the elementary truth that the whole is greater than the part. My opinion basically goes in favor of parliamentary supremacy, subject to whatever has been clearly reserved for the states under List 2. Then I have given my conclusions on interplay of legislative entries. Then I have given effect of overruling synthetics and chemicals. To the effect of overruling India Cement, I had 8 reasons, but here I have 9 reasons as to what would happen. And ninthly, I would say the Amendment Act 2016 has brought much needed clarity on the issue and is the correct position of law compatible with the scheme of legislative competence as under our constitution. I have already held that merely because industrial alcohol can be easily manufactured into or misused to becoming industrial alcohol would not grant states the competence to wholly regulate industrial alcohol. State legislatures only have legislative competence over what is intoxicating liquor as a beverage. Therefore, the judgment in synthetics and chemicals is good law and was most correct in postulating that state legislatures will only have the competence to prevent misuse in interest of public health. For the aforesaid reasons, I am of the view that although the judgment in synthetics and chemicals calls for only a clarification, which I have referred to above, it does not require any overruling. I have given my answers to the questions formulated in paragraph 32, my answers to the conclusions of learned Chief Justice in paragraph 33. Reference is answered in the above terms. The registry to place the matters before Honorable the Chief Justice of India for seeking orders for being listed before the appropriate bench. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General and their teams, learned Senior Counsel appearing for the respective parties, learned Instructing Counsel and learned Counsel for the respective parties for their valuable assistance in this bench, to this bench. Thank you.
Immensely grateful. Grateful to the court. Grateful.
I just signed it.
Last word on the matter to my learned brother, Justice Hrishikesh Roy. with your permission on both sides.
After listening so intently to the judgment authored by Sister Nagarathna, I nearly pulled out my pen to sign. It was so persuasive. This is perhaps the second time in a 9-judge bench combination we are sitting, and she's given a dissenting judgment. I counted 8 reasons while I was reading the judgment a few days earlier, but she clarified that 9 judges. But in any case, the judgment is now delivered, and since the case relates to intoxicating liquor, so I would suggest to the winning side that happy hour begins now. But
for the losing side
but
also,
yes,
they need alcohol, the same thing.
the embrace, but don't lose control. Either way.
Grateful to the court.
So alcohol is a panacea for everybody that needs.
Yes.
The winning and the losing.
We'll just be back.